Bismillahirrahmanirrahim. Welcome back to Shaikhain. Today we shall be talking about the non-disclosure agreements. What are the non-disclosure agreements, the NDA, and why it is required to be prepared or to be executed amongst the parties? What is the purpose of that? Contracts are the backbone of business relationship, governing the rights and obligations of the parties involved. Within these agreements, contract clauses play a crucial role in defining specific terms and conditions. Each contract clause serves a unique purpose addressing different aspects of the contract. A non-disclosure agreement, the NDA, is a legal contract that establishes a confidential relationship between the parties by restricting who can access and use certain information. NDAs are also known as confidentiality agreements, confidentiality disclosure agreements, or they may also be called non-disclosure contracts. So let us discuss what are the important clauses must be part of the NDA. Number one, I will say the confidentiality clause that defines the information that is to remain confidential. Other clause could be uses, outlines how the party can use the confidential information. Another important clause which must be the part of the NDA is the severability. If a court of competent jurisdiction declares any provision or any of the provisions to be invalid, the remaining provision remains intact. One more important clause must be the part of the NDA is the governing laws. What are the governing laws of the agreement? Should be properly and well defined in the agreement. Okay. Last but not the least, ladies and gentlemen, is the clause I will say exclusions. Exclusions define what is not considered confidential. NDAs can be mutual, where both parties are bound by the agreement, or unilateral, where only one party is bound. Non-disclosure clauses can be included in employment contracts, conciliation agreements, settlement agreements, or as standalone documents. Breaking an agreement is a breach of the contract which may lead to the litigations. Now, ladies and gentlemen, let us see how and where the NDAs must be used. Like companies use NDAs in many situations as to protect many types of information. For example, the acquisition process. When a company wants to be acquired, it is common to ask an interested buyer to sign an NDA so that the confidential information can be freely shared during the negotiation. Each side knowing it is safe, thus helping the business relationship flourish. Another example of the NDA is the employment contract. NDAs are used when a worker has access to the confidential information like business plans, customers list, marketing strategy, plans for new product, pricing plan, proprietary processes, trade secrets, or other information that gives the company a competitive advantages. An advantage that would vanish if the information was disclosed. Because employers do not want workers to distribute this information or start a competitive business at their own, they often have workers sign non-disclosure agreements to keep such information secure. Ladies and gentlemen, this was a brief video on the subject of non-disclosure agreements. Details and for further clauses we may discuss with our contract experts lawyer through WhatsApp or email given in the description of this video. Thank you and keep watching Shaikhain.